Hi everyone, my name is Martin Salvo and I'm the Director and Senior Immigration Lawyer at Salvo Migration, an immigration agency located in Brisbane, Australia. In this video, we will discuss the recent changes to Australian immigration laws, including the abolishment of the subclass 457 visas, impacts on pathways to permanent residency, and discuss exactly who is and who is not being affected by these changes. As well, we will talk about the additional requirements now imposed on permanent residents looking to apply for Australian citizenship. At the end of this video, I have compiled a frequently asked questions segment, which will hopefully answer most of the questions which you may have come up with whilst watching this video. So let's get straight into it. Important change number 1, the renaming and restructuring of the occupation lists used by both sponsored and general skilled migration visas. The changes to these lists took effect immediately from the 18th of April 2017 and affected anyone applying for particular sponsored and skilled visas. The previously known skilled occupation list has now been renamed to the medium and long-term strategic list, as I call the good list, and this list affects people applying for the 189 skilled independent, the 190 state nominated, the 489 family nominated, the 489 state nominated, and the 457 visa, which will be granted for 4 years if your occupation is on that list. It also affects the ENS direct entry applicants. The second change was the renaming of the previously known Consolidated Sponsored Occupation List, now called the Short-Term Skilled Occupation List, as I like to call the BAD list. Occupations on this list can be used by those looking to apply for the following visas: the 2-year 457 visa, the 190 state nominated, the 489 state nominated, and the 186 ENS direct entry. In addition to the renaming of these lists, 216 occupations were removed entirely, meaning that the occupations that now lead to potential permanent residency in future has been severely reduced, which we will discuss further in this video later. Importantly, RSMS visas have not been affected because RSMS visas do not require an occupation list, meaning that occupations that were previously eligible for the RSMS are still eligible. Important change number 2. The second change announced on the 18th of April 2017 was the abolishment of the subclass 457 visa, which will take effect from March 2018. What we know so far is that the 457s will be replaced by a new visa known as a temporary skill shortage visa. The characteristics of this new visa known so far are that it will have 2 streams. The first stream will be valid for 2 years when granted, and that is for those that have an occupation on the bad list. Those that have an occupation on the good list will have a 4-year visa granted that does have a pathway to permanent residency. Another very important characteristic to both of these streams is that in order to be eligible to apply for either, applicants will have to have 2 years of work experience in their occupation. Important change number 3. Although subclass 457 visas can still be submitted until March 2018, and there are still occupations left on the list, certain occupations have had additional criteria imposed, otherwise known as a caveat. If there is a caveat imposed on your particular occupation on the subclass 457, it means that your employer or your particular position will have to satisfy particular requirements, which are additional to what were in place prior to the changes. For additional information on the caveats imposed on each particular occupation, please have a read through our blog, as it contains some information regarding that specifically. So to help you understand the timeline of these changes and when exactly they'll take effect, let's work through a summary. From the 18th of April 2017, the skills lists were immediately reduced and renamed. Now these lists had an immediate impact on all 457 visa applications submitted to the Department of Immigration and not yet granted. This means that if your visa was submitted and still pending a decision from the department, unfortunately these changes do affect you, meaning that the validity period of your 457, as well as whether or not that 457 can transition to permanent residency in future, may be impacted. In addition to the changes that have already taken effect, what we know is that the department is also planning future change from the 1st of July 2017 onwards. And these are that the good list and bad list will be reassessed, meaning that the occupations that are on these lists may or may not be there from the 1st of July. That's not to say that some occupations may not be put back on and some may not be removed. We're not sure yet, that's yet to be determined. What we also know is that the English language requirements for all ENS and RSMS applications will increase to IELTS 6. Now at this stage, we suspect that this is in reference to transition stream applicants, considering that direct entry stream applicants had already had to provide IELTS 6 when making their application. We also know that the age limit will be reduced to 45 for direct entry applicants of the ENS and RSMS. However, at this stage, we are led to believe that the age limit of 50 will still apply to transition stream applicants. We also know that the removal of the English exemption for those earning above 96,400 for 457 visa applicants will also be removed. From March 2018, we know that the 457 visas will be replaced entirely by the new TSS visa and its two new streams. The good list will begin to apply to all RSMS and ENS visa applications. Now this is an important change considering that RSMS visas do not currently require an occupation on a list. We know that the permanent residency qualifying period will be extended from 2 years to 3 years, which we believe is in reference to 457 visa holders looking to transition to permanent residency. And lastly, all applicants must be under the age of 45 in order to apply for these visas. So now I'm just going to walk you through some of the frequently asked questions that we have been receiving since these changes were announced on the 18th of April. The first of which is, if I'm on a 457 visa, am I affected? Now, this is a bit of a difficult question to answer depending on your particular circumstances. However, your current 457 is not affected. What might be affected is your ability to transition to permanent residency. What we're unsure of is whether or not applicants who have a 457 visa on an occupation that is not on the good list, whether or not the Department of Immigration will allow you to transition to permanent residency after 2 years, if your 2-year mark is after March 2018, when the 457 visas are abolished. This is currently slightly unclear, but hopefully we'll be receiving further clarification from the department in the near future. A second very common question that we have been receiving is, I have already submitted my subclass 457 visa nomination, which is still pending with the department. Am I affected? Now, the short answer to that question is yes, you are. Any 457 visas that were not determined prior to the changes will be affected by these changes. So this means if your occupation is not on the good list, your 457 visa will only be granted for 2 years. And as far as we're aware currently, it will not have a transition period to permanent residency. If your occupation is on the good list, it means that your 457 will be granted for 4 years and will be able to transition to permanent residency after 3 years. A third very common question that we get is, my employer's nomination has been submitted and approved prior to the changes. If I submit my 457 visa now, am I still affected? Similar to my previous answer, the answer to that question is yes. If your 457 visa was not determined before the changes will affect you, meaning that the validity period of your 457 and your ability to transition to permanent residency will be impacted depending on the occupation that you were nominated under by your employer. Another very common question that we're receiving are from those that have already held a 457 and are approaching their 2-year transition period in order to apply for permanent residency. Now, a lot of people that have 457 visas are concerned that they may not be able to apply for PR. As far as we're aware currently, as long as your 2-year period is before March 2018, you should still be able to apply through the transition stream of the ENS or RSMS. So that's the key. As long as your 2-year date is before March 2018, as far as we're aware currently, you can still transition to your permanent residency before the major changes in March 2018. We are also receiving a very large volume of questions from people that have had their 457 visas granted prior to the changes in occupations that are not on the good list. So those that have occupations on the bad list. Now the questions have been relating to whether or not they will be able to transition to permanent residency if their 2-year mark is after March 2018. Unfortunately, at this current point in time, the laws are not clear whether or not you will be eligible to apply on the 2-year mark. The reason we say this is that what we know so far is that from March 2018, the 2-year rule will extend to 3 years. However, whether or not this will apply to people that already held 457 visas before the changes were announced is unclear. So hopefully in the coming weeks, more information will become available and we'll be able to update you accordingly. Other questions have come through from those that specifically had a 457 visa granted for 18 months. Now, the reason your 457 visa would have been granted for 18 months was because your employer was trading for less than 12 months at the time that they nominate you, so they were considered a startup. And hence your 457 visa validity was granted less than those that had been sponsored by an employer that had been operating for longer. The issue is that a lot of people in that particular situation will not be able to meet the 2-year mark because their 457 has not been granted for 2 years. Now, this raises specific concerns for those that were granted their 457s in occupations not on the good list, meaning that if you were to renew your 457, which you would have to in order to meet additional time on the visa to meet the 2-year mark, if your occupation is not on the good list, it means that your new 457 visa will be granted for 2 years. However, as far as we know so far, people that are granted a new 457 visa after April 2017 will not have a transition pathway to permanent residency. So what is unclear is whether or not there'll be a transitional arrangement for those that already had 457 visas granted that were trying to renew their visas to get to the 2-year mark. So things are still slightly unclear with regards to that particular question. But again, similar to the other questions, hopefully it will become clear in the coming weeks once we start to receive additional information. Other questions relate to how long do I have to apply for ENS direct entry applications and RSMS direct entry applications. Now, at this stage, as far as we understand, the plan is not to abolish the ENS or RSMS visas. So in actual fact, those visas can continue to be submitted after March 2018. However, the difference is that currently your occupation can be both on the good and bad list for the ENS. The RSMS has no occupation list. However, from March 2018 onwards, both visas will use the good list. So that's the difference. You can continue to apply for your ENS and RSMS visas. The difference being that from March 2018, the occupations eligible will be dramatically reduced to those on the good list. And one final very common question that we're receiving is, how long do I have until I cannot apply for a 457 visa? Now at this stage, the department has been a little vague in terms of when specifically the 457s will be abolished. However, they have suggested it will be sometime in March 2018. Traditionally, when visas are closed, it is those that cannot submit their visas prior to the date. So as long as your visa is submitted before the visas are closed, even if it is granted after the closure of that particular visa, traditionally the visas have been granted. However, that is not clear. The department may enforce particular rules that your visa has to be granted before the visas are abolished in March 2018. However, unfortunately, we can't really say at this point. We're just speculating. We hope that the department will allow applications to be submitted all the way up until March. However, we'll have to wait and see. So I hope this video has been helpful to you and your friends and your family. If you're looking for any more information, please feel free to also join our private Facebook group called Salvo Migration Community. In this Facebook group, you'll find more information relating to Australian visas, as well as our team answering members' questions. Now, keep in mind that this group is free and available to anyone that wishes to join. So we hope to see you in there.